I'll check on my phone, make sure. I think we're live. Let's make sure everyone could hear us.
Hey, everybody.
Yo.
Yeah, we got good news. Surprise. Yep, they can hear us. So we have Alice joining us.
Hey,
We also
guys.
have Brett from the Prosecutors Podcast.
Hello.
I've listened to you guys, so that's very cool. I listened to your podcast on different cases. We have some mutual friends, so that's always good. And I know you guys are busy. We're all busy, and I was just yelling for Brett. Man, I need some help. I don't know what's going on with all this stuff.
Neither do I.
We're just like.
So I came to help. I'm just kidding.
Alice
No,
to save the day.
Yeah, thank you, because there's so much going on, and like we're talking backstage. I wish we could have a little time off until October 31st, and then is this stuff normal? I don't know. I don't do what you guys do. What is going on? What happened today, and what's going on?
This is a problem for us because we try and record episodes on this with the intention of releasing them the next week, and it's like we keep getting overtaken by events. It's just
they say the wheels of justice turn slowly, and typically in any court case, it is the most boring thing in the world. It takes weeks, months, years for things to happen. Not this case. We are always behind on this case.
Well, when the wheels of justice go off the rails, all of a sudden they run a lot faster, and I think that's the problem here. So we're in train wreck territory.
Yeah. So speaking of off the rails, so I guess what happened was Judge Gold did do an update on some motions that she had, but really there was this one by Rosie. What's
Pretty
going on
much, the problem for him. Okay, so let's just walk through this. I mean, I'm sure everybody's already read the motion. Here's the problem. I mean, number one, and I think it's very important to point this out. They were not ambushed. This was not some sort of bullying thing. This is the no good deed goes unpunished. The prosecution was ready. They had their witnesses. They were going to go through this leak thing, and they were going to lay it right at the feet of these attorneys. Not Rosie so much, more Baldwin. And the judge did what judges do in every single case, and lots of cases that I've been involved in. When you're going to have a hearing, you go back in the judge's chambers, you chat about what's going to happen. I have been in cases where, much like what happened here, you sort of decide the contested issue in the judge's chambers. You come out, do a very brief sort of pro forma thing, and move on. And that's what happened here. And the judge, recognizing, I think, a couple things. Number one, how embarrassing this was going to be for the attorneys. Even though she was very angry at them for what had happened, it was going to be very embarrassing for the attorneys. It was going to be very embarrassing for the family of someone who had passed away in relation to this as the result of suicide. I mean, that stuff was going to be discussed. There was going to be discussion of the investigation of the leak that was going to happen at open court. These were all things that really, if we can avoid this by reaching some sort of conclusion that we can all agree on, that's the better outcome. And that's what happened in chambers. They reached a conclusion. It became clear, and she made it clear, and this is perfectly fine. She had the information. She had their filing that, look, I've looked at this, and this is the way it's going. And on the basis of that, they decided, they could have said, well, Your Honor, we want to have the hearing. They absolutely could have said that. And they chose not to. Instead, Baldwin left on the spot. Rosie said, I'm going to withdraw. I'll file something. And that was the end of it. And that should have been the end of it. And what happened today should never have happened, because when you tell a judge, I am going to do something, the next thing you do is you do it. And he did not do it. But I think the judge just moved forward with the expectation of, I have to find new counsel. And that's what she said in the hearing. And this today, I think, is surprising, inappropriate. And at the end of the day, and I don't want to continue to talk here because I know people want to hear from Alice and you. At the end of the day, I think this is going to be a bunch of nothing. I think these filings are just going to go away because they're filed by somebody who's not actually an attorney in this case at this point.
Yeah. So what are your thoughts, Alice?
I mean, that's a really good explanation of what's transpired up to this point. So for those of you who may not have read the filing today, the reason this is such a off the rails filing is what happened was this attorney has said, I'm going to file a motion to withdraw. He's not going to get in trouble in the sense of he didn't file the motion to withdraw, but what he should have done was file the motion. And if you are going to do something different than what you've told the judge, you're supposed to call the court so they know how to respond. He could have called the court and said, there's a change. I'm going to file a different motion. He never does this. Instead, he files this bombastic filing, lambasting the judge, moving to recuse the judge, which is a motion that an attorney can file. But in doing so, he's throwing a bunch of things into this filing that has intentionally been under seal for good reason. There's protective orders in this case. There are reasons that things are protected under seal, right? In terms of protecting the victims, the families, the integrity of the case. It will come out at some point, but there's a reason the judge has the discretion, and every court has said this. Judges have the discretion to run their court as they see fit to ensure that justice is done. And that may involve deciding when certain information comes out. He blows past all of this in his filing by basically putting all of these things that we didn't previously know about, that was discussed outside of the presence of the public, in this filing, and even lists certain things that the judge specifically sealed. When something is sealed, the public doesn't even know the identity of what is being sealed. That's the whole purpose. Sometimes knowing the title of something, knowing that someone's filed an affidavit, for example, is enough to kind of pierce through the confidentiality that the seal was trying to protect in the first place. So that's the first thing, is just this filing is off the walls. On it blows past all the kind of legal and practice decorum that lawyers are supposed to abide by. Not to mention, I think he's done some very questionable things ethically within this filing. So I agree with Brett that even as bombastic as this filing is, it's a bunch of nothing. Everything he says is exactly what you would expect to transpire in a courtroom, in judges' chambers, and nothing he's described is improper in terms of what the judge has done. He's writing it in a way that's supposed to sound very inflammatory and finger pointing, like, look what she's done. Guys, everything that he's listed, it's like a 10-point list of her supposed erroneous complaints, are completely commonplace and honestly good judging in the way that she handled it.
And look, I don't want to rant here, but we're all lawyers. That's the thing. I mean, we see it on television. We watch court TV. Everybody likes to argue back and forth and like, haha, prosecutors versus defendants and all this other stuff. But at the end of the day, we all recognize that we all have a very important obligation to the court, to our clients, to the system, to justice, right? And one of the things I love about the law is how prosecutors and defense attorneys work together all the time, much more than the average person knows. And they respect each other, and they respect the system, and they respect the process, and they respect the judges. And ultimately, I know that my job is to seek justice and uphold the law. And I know that the defense attorney's job is to do what's best for their client, not for them, for their client. And Richard Allen has been completely forgotten here. This man, in my view, in my opinion, wants to stay on this case because he thinks it's good for him. I think he likes seeing his name in the paper. I think he likes being able to write in the motion that Frank's motion has been praised across the country by defense attorneys for how wonderful it is, right? I mean, that kind of stuff. Like, no, recognize now that your presence is a problem in this case. We're not so far along that this is going to be unduly detrimental to Richard Allen. The trial was never going to happen in January, okay? It was always going to be continued. And what we have here, yes, impressive piece of legal writing.
I was saving that for you, but you already brought it up.
Good.
What we had here was an opportunity to start fresh with new lawyers. These are not the only attorneys in Indiana, and they are not the only attorneys in Indiana who can give Richard Allen a good, vigorous defense. They have become a distraction. And I think if this case weren't famous, and if it weren't an opportunity for them to be famous and to be on the next Netflix documentary or HBO, they would recognize that. And for the good of their client, they would back away. And they would help the new defense team in every way they could. And they would give them all the information they have about Odinism, about the Frank's motion, about lies they think the prosecution, all that stuff. They would give that to them, and they would let them go forward and carry it. But they're not doing that. And it's not because of Richard Allen. It's because of them.
And that's a great point. Sorry, Fig, I'll let you talk next.
Oh, no, I'm listening.
Read this motion. Other than saying that the accused, which is supposed to be Richard Allen, by the way, files this. There is no mention of Richard Allen. Typically, when you have a recusal motion or a motion about lack of removal for the attorneys, for the client, you talk about specific things the client will lose if you are removed from the case or if the judge is not recused. You would say something along the lines of, this particular client, this particular defendant has had a lot of difficulty connecting with people because of mental health issues, because of X, Y, and Z. People in his lives have, all left him. And we have created this bond. We have spent 132 tracked hours together building up this rapport. And for a new attorney to have to start from scratch would greatly be a detriment to this case. None of that is discussed in this motion. Not even a hint of why this is bad for Richard Allen. This is bad for the attorney. The attorney doesn't matter, right? We attorneys stand in representation of our client. We ourselves don't matter. It's supposed to be the client that we are the conduit for. But if you read this motion, it is a spotlight on the attorney and the attorney only, not on Richard Allen.
Yeah, lots of egos going on. It seems like it's a lot what I was getting asked today. People seem to be concerned that Richard Allen doesn't have representation and his constitutional rights are being violated. I know you guys touched on this a little bit before. Could you speak to that? Just people who are saying, oh no, Richard Allen doesn't have representation.
Well, if anything's delaying him from getting representation, it's this latest filing. I mean, the judge was in the process of finding good, qualified lawyers who are capable of handling a complex case like this. That was going to be the next step. I don't know what happens now. I mean, my expectation is he would have new lawyers by the 31st. That's not as we've said before, when a lawyer's removed, and it happens. Look, it happens a lot. And I've never seen anything like this, but I've been in lots of cases where usually the client says, look, I hate my appointed attorney. I mean, I've had cases where the appointed lawyer stands up. I had one case where right before the hearing, the client had actually taken a swing at him. And it was like, well, Your Honor, he just tried to punch me, so I feel like I probably don't need to be on this case anymore. And this was right before trial, and the judge has to remove them and find a new lawyer. And it's not like a lawyer just parachutes in from the sky. They're just lawyers waiting behind the doors to come in and represent a client. It's going to take time. In a complicated case like this, it's going to take time. That was always going to happen. If anything's going to delay it, though, it's a filing like this.
And people may not realize that a court case, it's not as if you're riding in a car and the attorney's driving the car, and all of a sudden, if your attorney vanishes, no one's driving the car and the car's going to smash into a tree. That's not how a court case works. There's not a moving vehicle. Rather, a court case, like I said at the very beginning, typically moves very slowly. And unless there's something pending before the court, the attorney doesn't have to be actively, quote unquote, driving the car. Right? Nothing happens to Richard Allen if he doesn't technically have counsel for 2 weeks, because there's nothing pending before the court. Everything's paused. No one is speaking to him from the prosecution. Right. No one's allowed to speak to him from the prosecution. Ethical attorneys wouldn't do so because they would do so at the risk of a bar complaint, being removed from the case, losing their bar license. I mean, these are very serious things to do for the prosecution. So no one's talking to him about the legal case. He's allowed to continue to go about his day where he is being housed in prison. He can continue to have visits from family members because those visits are not supervised by an attorney. If, let's say, an emergency happened, let's say he suffers some civil tort at the hands of the prison. A prison guard inappropriately hit him and he has a complaint. What should he do? He absolutely has remedies. He can report that through the jail. If something happened where he needed counsel for a discrete matter, and I can't imagine one that would be in his murder case, the court can be alerted and appoint him immediate counsel for that particular matter. There will never be a situation where he actually needed counsel for something before the court that he wouldn't have it. That, whatever that proceeding is, would be delayed until he had had representation. So that's just something I don't think a lot of people understand. They think it's this like moving train thing that no one's driving it. And so of course it's going to go up in flames. That's absolutely not what happens.
And, I just want to say one other thing about Judge Gull, because I see a lot of the comments. So Judge Gull, she hates the defense attorneys and she just wanted to punish them. And that's what this is about. If she had wanted to punish them, that hearing would have happened on Friday. That would have been punishment. The prosecution walked in that day with a whole lot of witnesses who were going to say a whole lot of bad things about these attorneys. They were going to do it on the record in a nationally televised hearing. It was going to be the kind of thing that's going to get sent to bar counsel. If she wanted to hurt them, she could have hurt them and hurt them badly. I mean, I've been in a situation where I've messed up and the judge could have like drugged me across the carpet in court, and they didn't do that. And I considered that an act of grace, and this was an act of grace. And like I said, what does she get for it? She gets this filing today.
She did seem disappointed in them. I think Alice might have mentioned this earlier, but she seemed upset and mad. I was just trying to read kind of her expressions and her tone, and she's just like, she didn't want to have to do this. No one wins, as you guys alluded to. Libby and Abby, their side, prosecution doesn't win. Richard Allen doesn't win. It's just everyone seemed disappointed there. The law enforcement did, especially with the leaks coming out. That was a lose-lose. And now it puts everything back, and it's just like, it's very frustrating.
And I'd like to note something. A lot of people, I think, immediately jump on the bandwagon like, well, the judge was mad at the defense. That's inappropriate. The judge shouldn't be mad at them. Remember what the facts are, bare bones here. And they ultimately may be disputed in terms of the variation and the nuance, but at base, the defense filed a memorandum on the day of the hearing on October 19th, admitting the leak came from them. That is all that matters, guys. Okay, we don't have to talk about whether it was just negligent or they meant to do it. Who cares? They have admitted that the leak came from them, and this is why it matters. The fact that in your courtroom, as the judge, if such a massive leak happens, it doesn't matter if it's on purpose or not. That is a massive breach of your duties. And in just about any courtroom in the nation, no matter what jurisdiction, federal court, state court, local court, that is going to have massive consequences for the attorneys who allowed that to happen. And in this particular case, it didn't even have to come out in an evidentiary hearing because the defense filed something to say, we did it. I did it. It was me. And so there was a reason for her to be angry. She was losing. I mean, her order was violated in a way that typically would get any attorney removed, no matter the type of case, whether it were criminal or civil.
And the other thing I want to say, I mean, to folks who are upset that they did this behind closed doors and sort of a secret hearing, I am too. I agree with you 100%. I wish she had taken them out there and just beaten them into the ground in public. I wish she had done that. But I don't think you can say the fact that she didn't do that shows that she's biased towards the prosecution. To me, that doesn't really make any sense. The fact that she allowed them this opportunity doesn't make any sense. The fact that she decided certain motions in this closed door meeting and not in open court, you can decide motions on unless there's a contested issue of fact. You don't have to have a hearing. Things like having cameras in the courtroom. She could have decided that on the papers. Things like whether or not to release his medical records to the prosecution, which she denied. She can decide that on the papers. So it's not like she had to do that in public. And the fact that she's deciding these motions back there was somehow problematic. This hearing, if there was an evidentiary hearing, would have been about the leak. And that was dealt with in this sort of private meeting. I wish she'd done it in public. I think she made a mistake. I think she should not have given them that grace. But at the same time, that's not evidence of her bias towards the prosecution. It might have been a lapse in judgment, but I don't think it's one that shows bias.
And to be clear, in the mistake part, that is completely like discretionary, right? Brett means mistake as in now in hindsight, because it's led to this additional circus. It's a mistake, but it's not a mistake under the rules or the law. She violated no court order, no rules or regulations, or even common practice by dealing with this in private.
Yeah, and there it is, because I think some people like to conveniently act like this wasn't stated, but this is the part where Baldwin is basically saying that, yeah, he was betrayed. He admitted that this leak happened, and he's given even an excuse for it there, a reason for it, and it's because he was betrayed.
Later on, you're going to have to teach me how to do all this fancy stuff where
I
you
know.
put stuff on the screen, because I don't know how to do that.
And I'm really glad you have this up here, because let me note this. A lot of people keep saying, okay, but the defense, even though they said the leak came from their office, they knew nothing about it. They were snookered. Someone stole it from them. So, of course, they're not at fault. Read this paragraph right here. This is not my words. This is not your words. Look at the defense's own words. it was their fault, because when you have documents of this sensitivity under a protective order, you have to take measures to protect it. When Brett and I, we prosecute cases with very sensitive information, not unlike the materials that have been leaked here. We have to keep them on a special laptop that holds nothing but those particular documents, locked with specific codes and VPNs and 3-factor authentication. Then we can never take that laptop out of a locked room that has a cipher lock. And when we go into that room, we cannot bring any electronic devices that can record or take pictures. And that's because all those, now, if he had all of those things, which he did not, because he said since the transgression, he now keeps them locked, meaning he never kept them locked before. But the protective order required that, and he had a lapse in judgment. He disregarded the order, which created the environment that allowed this leak to happen. So I just want to note that this is the defense's own words. This is not some simple thing where someone broke a cipher lock, broke the VPN, cut his finger off so that they can use his fingerprint to get into the documents, and lo and behold, they got, access to the documents. Not at all. When you create the environment that allows the leak, you are at fault.
And I just want people to maybe think of it this way. Imagine this were a child pornography case, and he was defending a child pornography case, and he left photographs of a child being sexually abused sitting on a conference room table when he brought a friend in, and that friend saw those pictures and took a picture and shared them. I think most of us would agree that is the kind of thing that is so egregious. Surely the defense attorney shouldn't just be slapped on the wrist and said, do better next time. This is as bad as that. Okay. I mean, we're talking about photographs of two murdered girls. One of which, I haven't seen the photographs. I never want to, but my understanding is one of those photographs, one of the girls is nude. This is so bad. And I see people downplay this, and I am sorry. Like, do not do that. Don't fall into that trap. Even if you really like the defense and you think the defense was getting to the bottom of a conspiracy, some other attorney can get to the bottom of that conspiracy too. And maybe that attorney will take this case seriously enough that they won't, number one, violate every obligation you have to protect the victims, but also, number two, violate the attorney-client privilege you have with your client and not share information with a third party in a way that frankly violates the privilege to the point that the prosecution could get access to your conversations with your client because you gave them to a third party. The whole thing, this is not a minor violation. This is not a little thing. This is a huge deal.
Right. And someone asked, if Richard Allen could keep Rosie on, like, why would you want to? Look what they did for you, representing you. That's not very good. You probably don't want that team on your side anymore.
And just another example of, why you wouldn't want him on your team. Remember, we talked about how this filing had nothing to do with Richard Allen, the accused in this case. The first quote that you threw up there, Rosie is like lauding his own writing in the Franks motion. That has nothing to do with Richard Allen. Richard Allen didn't write the motion. I've never praised my own writing in a brief before. And it's very inappropriate to do so, again, because it has nothing to do with the defendant. He's literally praising his own writing.
Yeah, look at me. And I get it as a business consultant. I get there. It looks bad. It has to look bad. I was thinking, what does this mean for Baldwin, his business? Like, just having this reputation. And then for Rosie, like, I guess he had to say something, but he made it all about himself, and he knew whatever he put out was going to end up on court TV and all these channels and be a big deal. So get what he was doing, but he also should have maybe had some more class behind it.
Well, and this goes to, really what Rosie should have done. Number one, I don't know. I realize that Baldwin's primarily to blame for this leak. It's my understanding that Rosie's messed something up earlier and might have sent some information, nothing approaching this, but and sent some information you shouldn't have sent something to. But I think the problem is you have a defense team. It's kind of like we talk about this sometimes. Talk about evidence that you're supposed to turn over, right? So say there's a piece of exculpatory evidence, and a member of our team has it, and they never let us know, and so we never give it to the defense. Well, that's not an excuse. We can't say, well, Your Honor, our hands are clean. We didn't do anything. We didn't know about this. This is just a member of our team, right? No, the whole team is held accountable for that. And I kind of wonder if even if Rosie is not responsible for this, if he can really separate himself from it, and if he can really like parse himself out of it And the thing is, the judge, Rosie, he can't handle this case by himself. He needs somebody else. So the judge was always going to have to appoint somebody else. So you're going to have to appoint somebody else. They're going to have to get up to speed. They're going to have to form some sort of bond with Rosie. It really doesn't make much sense to keep him. It doesn't really, I mean, I guess you get a little bit of institutional knowledge, but he also comes with the baggage of being attached to this. So just when it comes to what is best for Richard Allen, you know, if the trial's going to be delayed anyway, which it is, I mean, Baldwin has no leg to stand on. Rosie's at least got an argument. He should be able to stay. Trial's going to be delayed anyways. Attorney's going to have to get up to speed anyway. Discovery's going to have to be done all over again anyway. What is best for Richard Allen? Is it to start with a clean slate, or is it to keep Rosie on the team? And I don't know, if you care about Richard Allen and you want him to have the best representation, I don't know how you think keeping Rosie on is the best case for him.
And could you guys touch on that? This has came up throughout the case about being late on discovery. I hear people saying, oh, McClellan was late on discovery. So I looked into it and I checked, I contacted some people and they're like, no, he's not. What are you talking about late on discovery? You could do discovery throughout the whole, process, even up until the trial, even sometimes during the trial. So could you kind of explain turning in discovery, that process, what it normally looks like as far as deadlines?
So typically, I mean, every court kind of has their own rules here. I think I've heard here that the November 1st is the deadline, which has not passed yet. But you're right that the investigation continues up all the way into trial, right? You're constantly interviewing people. Those generate new reports that you then turn over because you're trying to figure out how you're going to present the case. Of course, you have an investigation file that led you to the arrest. And typically you turn that over very early on. But when you supplement it and you have an ongoing duty to supplement, both the prosecution and the defense, by the way, have an ongoing duty to supplement the discovery. That's very typical. I mean, we are literally interviewing people in trial as things come up. Right? We may hear something for the first time when we talk to a new witness, and then that leads to another interview, and it leads to another interview. So what we do is write up those reports and then turn them over as soon as they're ready. They're not going to be ready on the day one when the individual's arrested because we didn't know about that information. But these are not static cases. You don't have a sealed case the moment that you issue an arrest warrant. Very much is ongoing and sometimes is reactionary to what the defense does. They do their own investigation and they turn things over. So this is a very dynamic process in every single case. And when it comes to exculpatory information, those sorts of things, you need to turn over certain information at a certain point in time. Doesn't mean you have to wait until the last moment, but none of those points have come up, right? For example, you typically have to turn over all previously sworn statements of a witness before they testify. And that's so the person can, who's going to cross-examine, can look at what that person said so that when they take the stand, there's cross-examination fodder and they know if they're telling the truth or telling all of the truth. So that makes a lot of sense. That information under the law is not due until the person takes the stand. Oftentimes, most prosecutors' practice is to turn it over sooner than that. But in terms of you've done something wrong, it's not wrong until a very late point in time under the rules. So, if you're hearing a lot of they've missed deadlines, unless they've actually missed a court deadline, which I've gotten no indication of, there's been no violation of late discovery.
And I think another thing people need to remember about discovery is voluminous. And it is not that you just take all the discovery and throw it to the defendant. You have to review it yourself. You have obligations to do things like redactions. There's personal identifying information that you don't just turn over, like Social Security numbers. I mean, when we're turning over discovery, it's always such a process because the people who work with us are having to go through it and they're going to redact everything and make sure everything's appropriate before you turn it over and all this other stuff. And so when they're talking about, man, we've gotten so much, and because that's what's funny about the defense, right? On the one hand, they'll be like, they're late on discovery. On the other hand, they'll say they are just piling us up with discovery, right? Well, I mean,
you can have it both ways.
Yeah, it's an ongoing process, and you have to have discovery complete in enough time for the defense to review it for the important deadlines in trial. If the prosecution didn't actually, like, imagine, for instance, prosecution didn't turn over something that goes to like a motion to suppress, and the motion to suppress deadline passes, because usually there's a deadline for those kind of filings. And then the prosecution turned it over. What the defense would do is they would say, prosecution, just turn this over to us. This is material to a discovery question. move the court to allow us to file a motion to suppress, and the court would grant that. I mean, there's ways for working with all this, and this goes back to what we were saying earlier. This is not the way it's supposed to go, guys. The defense and the prosecution, they're on opposite sides. They both want to win. They both are zealous advocates for their position, but they are supposed to be working together constantly to make this a smooth process where everyone's rights are upheld, where the law is respected, and where you can move towards a trial so that the defendant can get their day in court and we can decide whether or not they committed this crime. That's the way it's supposed to happen. And that obligation is on both sides. And it is so easy to praise the defense for they're just really sticking it to the judge and sticking it to the prosecution. That's not actually how it's supposed to work. They are supposed to be zealous, and they're supposed to question the prosecution. And if they've got evidence that this was some sort of odious conspiracy, they're supposed to bring that and they're supposed to hammer it. But that doesn't mean doing it in the way that we have seen, a way that is delaying this trial and derailing this case.
Right. And there was, I call it the Odinite Manifesto, that memorandum. There was names mentioned in there too who were accused. Maybe you could clarify, like, because they're talking about suing, because their name was brought up and being accused of a murder. I don't think they can sue, but maybe you guys can. Yeah. What's your guys' thoughts on that, and what legally could those people do?
I mean, nothing, and that's the problem, right? Like, the privilege exists because we are all officers of the bar who are expected to uphold a certain standard, right? So the expectation is you don't need to be able to sue attorneys for defamation. Number one, you want attorneys to be free to make arguments in court. That's very important. And number two, that they hold themselves to a higher standard, and so they're not going to make defamatory statements, and so therefore you don't need to sue them, right? So if you wanted to file something, let's just imagine a world, which is not this one, where you needed to put all that information in a Franks motion for the purpose of meeting the standard in a Franks motion. Imagine that was true. There's a very simple way to do that. You file it under seal. That's what you do. I know we all want to read it. We want all the information, and we want to see it, and we want to see it now. We don't want to wait till trial. We are not the deciders. We don't decide whether or not there was a Franks violation. That's for the judge. The information needs to get to the judge. And the judge can then consider that information. And if there needs to be a hearing, which will be public, they can have that hearing. But if they don't meet the standard, we don't need to have the hearing. They can deny it. If later on you think that was an error, you can appeal that to an appellate court. Like, there are processes for all of this. And they knew that. And if you read their filing today, and I keep saying they, but it's Rosie. He says, like, well, there was no protective order over this. There shouldn't have to be one. You should know, if you're going to name people and accuse them of sacrificing 2 girls to Odin, if you're going to do that, you as an attorney know that's the kind of sensitive information which, when you read the rules, allows you to file something under seal. They didn't want to file under seal because it wasn't about convincing the judge. It was about issuing a press release and taking advantage of what someone in the crowd called a loophole. And I get it. That's what they did. They took advantage of a loophole in the protective order, and they basically issued a press release through a court filing. That is improper.
Yeah. Do you guys, I know I have this on the screen here. These were other things that were, I guess, mentioned today by a filing from Goal. I don't know if you want to touch on any of these things that are up in a little small font.
Oh, this is the order that she issued.
Yes.
Yeah, so I mean, it's a couple things about this order that I think are interesting, and it's hard to say exactly what's going on here. Some people have speculated that this is like backdated in response to what was filed today. I will say this: it is my experience that, for instance, you go to a sentencing, you have a sentencing, right? Judge gives somebody a certain amount of months. They then fill out a judgment, sign the judgment, date the judgment. The judgment won't actually be filed on the docket for a few more days because it has to go down to the clerk's office. The clerk has to deal with it, and eventually they put it up. So it is never entered on the day that the judge actually executed the judgment. And so just because this came out today does not mean the judge issued this order today. The order is dated from the day of the hearing. I think there's a couple possibilities of what happened here. I think one of them is the judge went ahead, made this order, sent it down to the clerk's office, and then said, hey, Rosie says he's going to file a motion. He says he's withdrawing. He says he's going to file a motion. When he files a motion, go ahead and enter this order. right? Then he never files the motion, and so the judge is like, okay, whatever, enter the order that I signed on the date. I think that's a possibility. And the other possibility is it just took a while for the clerk to file it. As far as what she basically ruled on several things that had been proposed by the defense, the broadcast order. She's not saying it won't be televised, but I think it's one of those things where we're going to take it hearing by hearing. This last hearing was going to be televised, for instance. I think the prosecution had asked for mental health records because the expectation was that he would claim insanity or he would claim he was incompetent. And I think the judge is essentially saying, not appropriate yet. If he ever makes those claims, maybe it will be. And then, the Frank's hearing stuff is I think pretty straightforward. It's just sort of an update on that she's still wading through. Because that's the thing, the judge has to consider all this evidence too. When she's looking at filing, she's still looking through basically everything they filed. They filed a very extensive, we talk about the 136-page motion. That's just the motion. The attachments were voluminous. So that's essentially what I got from that.
Great. Alice, anything to add on that?
No,
The-
just, I
those
mean,
ones, yeah.
the way you read that order is very typical, right? But remember, the Frank's motion that we've kind of been talking about is not the only motion pending before the court. There are a lot of motions filed by both sides, and each of them have to be resolved by the judge. It's a almost administrative matter when you actually get down to brass tacks of granting or denying each order. And that one in particular was dealing with a lot of things. And that takes a lot of time to make sure each particular motion is dealt with in the right way. It goes to the clerk's office, which then, issues the actual order, publishes it on the docket. And in my experience, I mean, for example, I had an order granted, and it was one order, like a 3-page motion, 2 weeks ago. And it appears somewhat on a small docket, but it's not fully public yet. I know what the judge's ruling is because she made it on the bench, and I've gotten communication from the court that my motion was granted, but it does not appear on the public docket. So today's order was not written today, very likely. I don't know that for a fact, but just the way it reads as what she said on the bench at the hearing, and then it was reduced to writing and then ultimately entered onto the docket.
What else?
Well,
There's cats going crazy. I'm trying to catch up a little bit.
So I guess the next step, technically this is a motion. Is that right? Styled as a...
It's styled as a motion.
I only say
disqualify.
The reason I say it might be is typically what's typical in this case has not been typical, which is why I say I'm not sure. When there is a motion, there's usually a right of response. And so, typically a response would be filed in a normal case. In this case, the court doesn't have to wait for a response. The court can rule. A lot of people have said who may think that the allegations lodged by Rosie against the judge are serious. And if she were a bad judge or a corrupt judge, who's going to put her in her place? I mean, she can rule on this order. And then there is the right to appeal, of course. But I think this motion will be dealt with swiftly, and it might even be dealt with in a manner of that he's disqualified because he already withdrew from the case, and he can't unwithdraw from the case because he's done nothing to unwithdraw from the case. And so then you have a filing by an attorney who is not on the docket, which is improper and would be struck by the clerk of the court. That's a very administrative thing. That has nothing to do with the judge. So, for example, if I filed something and I have not entered an appearance in a case, but I'm a lawyer, I have a bar number, I have a filing number. If I filed something and just accidentally filed it on the wrong docket, court would see that I'm not an attorney of record and would strike it administratively as if it didn't go on the docket because I do not have the right to file there. That may happen here. We'll see. But he technically doesn't have a right to file anything in this court.
Yeah, that's what I think should happen, frankly. I think everything that was filed today should be struck. I think he's no longer an attorney in the case. And I think he's no longer an attorney as of last week. And, the whole like filing a written motion later is a courtesy. I don't know why he wanted to file a written motion later. Maybe it's because he knew he was going to walk out of that courtroom and change his mind. Maybe, like it feels like playing a game with the court, right? Like he makes that statement to the judge, which results in the cancellation of the public hearing. And now he's like, never mind, right? But you can't do that. I mean, he had already, once he makes that statement to the judge, I mean, he's essentially withdrawn. He's going to file something later, he says, but It's not like if he had never filed that, the judge's hands would just be tied because he's not filing something. Like, she can take the action that is appropriate. And I just want to make something very clear. When these two men were appointed, Alice and I talked about them. We went through their bios, and we talked about how we liked the fact that they were appointed because they looked like serious people who knew what they were doing and had a lot of experience. And we hoped that because of that they would give Alan a good defense, but also one that moved the ball forward, because there is nothing worse than when you are across the V from somebody who either doesn't know what they're doing or is malicious. That is the worst thing for everybody. And it looked like these guys weren't that. And I just want that to be clear, because I'm not happy that it turned out this way. I'm not happy that it went this way. This is not good for anyone. But these attorneys have shown who they are now, and I think the judge was well within her rights to accept that they had shown who they were and to remove them and to try and get the serious, thoughtful attorneys that we all hoped they would be.
So could you guys respond to this question? Have either of you seen judge removed for what Rosie is claiming?
No. I mean, it's just such a claiming the judge doesn't like you is like the most bare bones recusal request ever. She's going to make the decision. It'll be up to her. She'll decide whether or not to recuse herself. She'll decide whether or not she's biased. I realize that seems strange to people, but you don't want a system where you can just file this and all of a sudden everything shuts down. We have to bring another judge to decide whether or not you're biased. So basically, she will, if it's even a valid motion, like I said, I think it'll be struck. New attorneys will be brought in. They may very well want to file something. New attorneys, without all this baggage, may want to say, look, after everything that's happened, judge, there's no way you can be unbiased. File that. But no, I mean, she's not going to recuse herself based on the motion that was filed today.
I know I text you. I'm like, is it up to her? Or does someone else have to step in? But it makes sense how you explain it. Otherwise, I just do that all the time and just delay things.
Right.
It's just so odd. This is all very new to me.
And as to the question that's on the screen right now, it's not about money. Like they essentially are pro bono for Richard Allen. I mean, they're appointed attorneys, but he can't. The judge has control over the court and can decide whether or not, like if Richard Allen paid them a bunch of money, it doesn't mean all of a sudden they can come back on the docket. Like she can decide whether or not an attorney can be on a case or not. And I mean, they're done. They're done. They're not. I mean, look, as I told somebody today, it's a strange world. So there's a non-zero chance that tomorrow she issues an order recusing herself and Rosie just remains the attorney on this case. I'm not saying that's impossible, but
she shouldn't.
I wouldn't bet your house on it.
She shouldn't.
That'd be so Delphi.
It would be something else.
But
like we said, the things that he's listed in his motion that apparently she's done wrong, none of them are improper. He hasn't cited a single rule. He hasn't cited the law. He hasn't cited anything improper that he's done other than she doesn't like us. You know what? There are cases where 100% of my filings, the judge rules against me on. That is not grounds to recuse a judge at all, right? That happens. They have to make certain rulings. So even if that's the case, every single ruling is against you. You can appeal every single one of those. We have a judicial system that is set up so that no one judge is the ultimate judge in that case. And there's a reason for that. So that if you think you're stuck in a bad court, you got to litigate it. Then you have the right of appeal and you get to appeal to a totally different judge or judges. And there's yet another appeal in most systems. And so everything he's listed is typical judging.
Alice and I had a trial once where the judge sustained every objection against us and overruled every one of our objections. It was like, can we just win one?
And it was like a month-long trial.
It was a month-long trial. And it was just like, oh, God.
It was like thousands. I mean, it was almost apologetic when we'd object. Like, object, I know it's overruled.
I know you're going to overrule, but I feel like I have to.
Oh, geez. So, what are you guys up to? We'll get back to a few questions I'm going to go through, but like, what's next for you guys? You have episodes coming out. You're recording.
Oh.
You guys want to?
Y'all keeping us busy, I guess.
we're trying to stay on top of this case, but like I said, I mean, it just feels like it moves so fast. I mean, we could record something new every day and we'd still be behind. We got the prosecutors where we're doing cases, and I'm like, I feel more and more like the prosecutors is like a warm blanket I could just wrap myself in, because it's not this insane ongoing madness, whereas legal briefs is every day. It seems like some new, and in this year, I don't know what it is. I don't know what's in the water, but between the Murdaugh trial and those defense attorneys, this case in Idaho, they're trying to like change the last 250 years of law about how grand juries decide cases. It's like, what is going on with you guys? Like, I don't even know anymore, but it's just crazier every day.
It seems like always something new and exciting just to keep us on our toes. And right when things we like for them to calm down, it's something else.
Yeah, and I'll say one other thing about this whole issue that's arisen. We talk about sometimes I do all the appeals for our office, so sometimes lawyers will come to me and they'll want to do something. They'll want to do something that's a little edgy, and sometimes I'll talk about like you're building a bomb into your case. Like you can do that, but if you succeed, there's a bomb in your case, and if you win, then that case goes on appeal. I'm gonna have to use all my charm and rhetorical skills to try and convince some appellate judges that you did the right thing. The one thing I'll say about this, and the one thing that's troubling, is there are decisions that are immediately appealable and there are decisions that aren't. And typically, whether or not a judge recuses themselves and whether or not lawyers are removed is not immediately appealable. So if the judge decides to go ahead and remove these lawyers and that she should not recuse herself, new lawyers will be appointed. The trial will move forward, and Richard Allen will have a trial, and let's say he's convicted. Well, then his new attorneys, which is kind of weird if you think about it, his new attorneys will be able to file an appeal and say, hey, we were really not that awesome, but those last guys, they were great. And when she removed them, that was a violation of his due process rights. And oh, by the way, she was biased, and so she should have recused herself. So that's the unfortunate thing about what's happened is assuming she does what I think we all will do, we all think she'll do, which is continue to remove these people and then continue with the case, there is a bomb in the case. And whether it goes off or not will have to be decided at a later point, but it's just, it will be an appellate issue.
All right. I don't know if you can see this question on the screen.
So could they subpoena the men referenced in the police reports? I assume the question is, can the defense subpoena them? Yeah, absolutely. Not like to appear right now in their living room, but if this case goes to trial, the prosecution has a right to subpoena witnesses, as does the defense. Now, the defense nor the prosecution can force anyone to talk to them ahead of appearing on the stand. And so that could be a risk, because if you're accusing me of being an Odinist who, sacrificed 2 young girls, I probably don't want to talk to you ahead of time, but the court's going to make me show up for trial and I will take the stand and I'll answer your questions. But you don't typically see that happen because, again, I think this filing was meant to be a press release. It wasn't actually meant to investigate. It's very unlikely that they went out, and they can do all the investigating they want. Anyone can talk to them. They can't really force them to talk to them, but there's a lot of investigating to be done. That was not the purpose of this Frank's motion. It was to get their names out there so that people would begin to Facebook stalk them, to talk about anyone but Richard Allen, and to get basically confusion spun up into the air. That was the purpose of mentioning them. But yes, the prosecution doesn't have any additional tricks up their sleeve for trial that the defense don't have access to as well. They also have the power of the court to ask witnesses to come and testify. But that only means to get on the stand and to swear to tell the truth, the whole truth, and nothing but the truth. They don't have to do other things. They don't have to give them certain answers. They don't have to give them interviews outside of the courtroom, for example.
I know this case is super unpredictable, but what would you predict on the Frank's hearing, how that will be handled by the judge when it does come across?
Well, it wasn't a real Frank's motion. I mean, I think one thing that's good for Richard Allen, assuming these jokers go away, is new lawyers will be appointed. And I think they will essentially have the opportunity to review what's been filed and withdraw it and replace it. And the judge ain't going to hold them to this stuff. And there may be a legitimate argument for Frank's motion. I mean, if you think about it, They filed a 136-page motion. They don't start talking about the Franks motion until like page 105. They don't cite Franks until the last page. They later on had to file a supplemental motion. Usually when you file a supplemental motion, it's because like yesterday, the Supreme Court decided a case that's really good for us, and we want to make sure you know about it. They were like, oh, so we forgot to cite any Indiana law or lay out the standard or anything. Oops, here it is. That is, I mean, I've dealt with Franks motions before. That is not how it's supposed to go. So, I think a real Franks motion may very well be filed, because you really have to file a Franks motion if you're going to attack a search warrant. Otherwise, it can be problematic. But I think they're going to file a real Franks motion. They'll lay out the law. They'll lay out how they'll say things like in State versus, Johnson, a case very similar to ours, where the police officer in that case said this in the affidavit. That's the exact same thing that the officer said in this case, and they were both left out this thing. And when they did that, the Supreme Court of Indiana said that you can't do that, and they granted the Franks motion, and that's why you should grant the Franks motion here. And that's the way legal reasoning is supposed to work. So I think what's going to happen is you're more likely to see that. People were asking about who will decide whether or not she recuses. In most jurisdictions, the initial motion to recuse is decided by the judge. It's Indiana Trial Rule 79C4, and there's a lot of cases about this. The judge is presumed by law to be unbiased. To overcome the presumption, the party seeking to disqualify must establish actual personal bias. And it's a question of whether or not the trial judge should disqualify himself or herself. So unless there's some other law I'm not aware of in Indiana, like in most places, the decision about whether or not to disqualify yourself initially will be made by the judge, and then later on will be decided on appeal.
Right. And I think the question here, we kind of touched on that earlier. Alice touched on that. We showed kind of the statement that showed that, yeah, Baldwin did pretty much admit to it, that it was their bad. And I think he paid for it.
I mean, that's the thing. It's his own words. He hired an attorney.
I think
Yeah,
I think
who
it's
does
fair. I
that?
think it's helpful to point out here, though, that we know from Baldwin's own filing that his office was the one that leaked it. And remember, by leaked it, he created the environment that allowed it to happen. And by the way, it may be worse than that, but we're just giving him all the benefit of the doubt and just going with his own words. What happens if that happens? What could have happened at that hearing is he could have had his butt handed to him. And if it came out that it was more than just he had the environment that allowed it, that he actually had some role in it, then there could be much more serious consequences for him, such as being removed from the bar, potentially being prosecuted himself, being held in contempt of the court, et cetera, et cetera. And the reason the judge did what the judge did, which was have a private conversation with the attorneys in her chambers, was to avoid that for the defense. It was a grace shown to them.
Yeah, it seems like she did them a solid.
And as far as the directly leaked, we're not saying he directly leaked it. And he's not admitting he directly leaked it, but he is admitting the leak came from his office. Now, we don't have any inside information. We're reading the same things you guys are. I don't know what Fig has heard. We were on with Murder Sheet. They indicated that there was some information that they had received, that perhaps this leak was a little bit more than someone just walking in and seeing some stuff and taking photographs, that there was information that was leaked that would have been difficult. There was more of an ongoing thing. I have no idea about that. The investigation is ongoing. I think you will learn the truth of that. But I think the point that we've been trying to make, and I just think it's indisputable, is even if it happened exactly the way Baldwin said it did, he recognized it was serious enough. He needed to hire a lawyer to come in and argue that for him. And if he needed to take the stand, he didn't want Rosie asking questions. He had he had his own lawyer who was gonna handle that. And I think that tells you that he knew it was serious.
He knew,
at the very beginning.
right? He knew something was coming.
And remember, that same filing, that strange memorandum, he didn't just admit that the leak came from his office. He specifically said, don't sanction me. If he didn't think this was serious, he wouldn't have made that argument, right? He recognized the seriousness of this. Sanctions was like kind of the least of his problems, honestly.
Now, Brett, I heard you kind of respond to this and give a good example. I'm not saying Alice can't come in and give this. I don't know who wants to take this, but I did like Brett's explanation of just how witnesses, they could get things wrong. And it's not necessarily that someone's lying, that law enforcement was lying. So whichever you wants to kind of take this and address kind of witness statements.
Well, I think I'll go ahead since you put me on the spot. I'll do my best. And Alice is smarter than I am, so she can come in and clean up.
Well, I know.
So just so you guys know what a Frank's motion is, Fourth Amendment guarantees you a right to privacy and all your stuff. Can't violate that privacy without a warrant. Ordinarily, if you get a warrant, the courts have said, look, if you went to a judge and you presented an affidavit and that judge looked at it and in their good judicial opinion decided that meets the standard and granted you a warrant, we as judges who weren't there, we're not going to second guess that. Unless it is just so obviously devoid that no reasonable judge should grant that warrant, we're not going to second guess that. But if you can show that that judge was misled and that the affidavit that was provided to them was so deficient that it made a judge grant a warrant where if they had known the true facts, they would not have granted the warrant, then we're going to take a second look. And that's what Frank's is. I think it's Frank's v. Delaware, where the Supreme Court said there is this one narrow circumstance in which we can go beyond what we just see in the affidavit and question things. But the court also said, we know what's going to happen once we issue this opinion is every defendant in the world is going to say, well, the affidavit was a lie. So therefore I get an evidentiary hearing. I want to be able to question who wrote the affidavit. So the Supreme Court said, can't do that. The burden is going to be on the defendant to show before they even get an evidentiary hearing that whatever they're saying was wrong or was left out was, number one, intentionally misleading, was a lie or was intentionally misleading. It's not good enough if it's negligent. It's not good enough if it's wrong. It has to be intentionally misleading. And it has to be so important to the affidavit that if you took it out, or if they intentionally misled you by leaving something out, if you put it in, the judge looking at it would have said no probable cause. So that's the standard. Very high burden. The example that was given in the comment was at one point in the affidavit, it says that one of the witnesses saw a man wearing a light blue jacket walking down the road. And in fact, they didn't say light blue. They said light, maybe tan, maybe muddy jacket. And the defense is like, haha, they said light blue. But in the affidavit, it says light tan, jacket. Okay, here's the problem. That fact doesn't really tell you anything about why they should or should not be able to search Richard Allen's property, number one. Number two, it's not clear that it's intentional. As we said, officers, when they're writing these things, might conflate things because if they've seen the video, they see that the person is wearing a light blue jacket. They read the affidavit, they see light jacket. They might very well write light blue jacket in the affidavit, not even thinking. But assume for a second that they were completely lying, that they totally made that up. They made that part up. Take it out. Take that part out of the affidavit and then read the affidavit. And if in reading the affidavit where it notes that Richard Allen put himself on the bridge at the right time, basically said he talked to all the people there and that he was wearing the clothes and is essentially a bridge guy, whether he committed the crime or not, is there still a probable cause to search his house? The answer to that is going to be yes. And that is why the Frank's motion, if that's all they have, and maybe new lawyers will do a better job of crafting a Frank's motion, but if that's all they have, that's why it's going to fail.
Yeah, and I think that could be tricky, right? So the witness could have said, I saw, the man in a blue jacket while he was on the bridge, but then someone else could say, well, he was walking and I saw the tan jacket. But when they were showed a picture of him, they're like, oh yeah, that's him, the one in the blue jacket. Thanks for showing me the picture of him. But when I saw him, he was wearing that tan jacket, which was underneath the blue one. If he got blood on it, maybe he took it off and now he's a tan jacket. So I think they omit certain things to paint a certain picture. I think that's pretty common. And I even saw the prosecution do some of that. It seemed like they omit certain things because why would you, in a search warrant, why would you talk about other people being involved? Why would you include all these other things and have to explain why Bigfoot wasn't involved, why aliens weren't involved, why Odinites weren't involved? It's not about that. It's about getting a search on a specific person. So I don't know. It's weird when the defense acts like they don't know law. To me, being an outsider.
Well, because it's effective, because most people don't know law. And you see that, in the comments, I don't want to call out Rose, but Muddy and Bloody, they lied. Doesn't matter. It does not matter if they lied. The law says it has to be a material omission or lie. But the defense knows that the average person doesn't know that. And so just like the Odinist stuff, It's basically for the public consumption. They're not expecting to win this, and they're not going to win it.
And remember, everyone, the Frank's motion is to attack the search warrant. The search warrant, not the arrest warrant. So this is to search his property in furtherance of the investigation. You have search warrants for lots of things, not just for the person you ultimately think is the suspect. You have a search warrant. The standard is you think that there will be evidence of a crime there. So in this particular case, we know of dozens, and there may have even been close to hundreds of search warrants in order for them to find information to further in their investigation. It's very possible that they would have had the search warrant executed on Richard Allen's home and ultimately decided from their investigation that they did not have enough evidence to issue an arrest warrant for him. So this is part of the understanding the differences in the motions here as well.
So to answer a couple questions that have come through, first I want to address Birdie's question because I think this is important. Eyewitnesses are notoriously unreliable, but remember, and this is why what the defense did was so clever. This is not about the ultimate question of guilt or innocence. Guilt or innocence is beyond a reasonable doubt, and eyewitnesses are unreliable and they can be attacked, and maybe they will fail in front of a jury. This is about probable cause to search something. And all probable cause asks is, if based on the evidence you have, which is what people are telling you and what you're seeing, is it reasonable for you to think there might be evidence of a crime at the place you want to search? That's the only question. So if a witness comes to you and tells you, hey, I saw, there was that shooting. I was there and I saw a guy with a gun run into that building over there, building number 3. And you go to the judge and you say, look, we have an eyewitness who says they saw right after the shooting a guy run into building number 3 with a gun. It may turn out that eyewitness was like high as a kite and didn't actually and hallucinated the whole thing. And you got the search warrant, you go into building 3 and you don't find the gun, but you find like 10 kilos of cocaine, right? Well, guess what? You can still prosecute him for the 10 kilos of cocaine because it was reasonable for you as an officer to believe that what you were being told established some probable cause that a reasonable person, upon hearing that witness, would think there's going to be evidence of this crime in this building. And that's the only question. And it's the same. And that's why the Odinism thing was so strange, because all that Odinism stuff is trial arguments. It's all trial arguments. Another example, the resource officer. When Richard Allen initially talked to the research officer, he put himself on the trail at the right time. Now, when he spoke to officers later, like 5 years later, he said he left much earlier. Not surprising he would say that, right? Given what he's facing. The defense in the Frank's motion wanted to argue, how can we believe this resource officer? Because, he wrote down the street, like the street name or something in the name. And so clearly can we really believe him? Great argument in front of a jury. Great way to attack that officer's testimony when he's on the stand, when you're trying to decide whether or not there's guilt or innocence. But when it comes to this question, it was reasonable for the police officers listening to the resource officer who gives them that information to rely on it in seeking a warrant. It's different standards. And that's what the judge is having to determine. And that's what the judge is having to apply. And you really have to try, and I know it's hard, but you really have to try to separate these things out into different buckets when you're looking at different phases of the trial.
And that's a really good point that Brett makes here. We've talked a lot about the Odinism in some ways of saying that we should disregard it. That's not what's happened here. The Frank's motion is not the appropriate place to make the Odinism argument. The judge is not shutting down that line of argument. They can absolutely walk into trial and make that argument, and they may or may not, depending on how this case goes. But the Frank's motion is not saying you can't bring this argument. You can't investigate this. Not at all. It just doesn't have a place in this particular motion for this particular standard. It has nothing to do with the search warrant. And so those who are kind of watching this go on and may not understand that the judge isn't shutting down zealous advocacy or alternate reasons why Richard Allen is not the murderer. Those are all absolutely fair game. It just doesn't have a place in this particular motion, and it does not grant the relief that is requested in the motion, which is to attack the search warrant.
Yeah, so one comment, so Richard Allen does put himself there at the crime from 1:30 to 3:30. It is in the documents. I've read all the documents. And then, recently that changed his alibi was at home. So I thought that was interesting because they subpoenaed CVS. So, I'm open. So if they subpoenaed CVS and CVS says, no, we have him that he was clocked in from 1:30 to 3:30, or his phone records show that he was somewhere else actively using his phone. But instead, what they came with in that memorandum was, oh no, he was just at home from 12 to 1:30. At home. Is that the worst alibi in the world?
Well,
or-
I mean, look, it is a bad alibi, but once again, I get it, and we're to blame, you're to blame. I blame Alice mostly. But this is what we do. We talk about this case, right? And we talk about all these facts, but this is all going to come out at trial. There's going to be a trial. And at trial, we're going to see the evidence the prosecution has that he was actually there, and we're going to hear his contrary evidence. I mean, remember, talk about Murdaugh. When Paul and Maggie were murdered initially, if you were following that case then, what everyone said was it wasn't Alec Murdaugh because he had a rock solid alibi. He was with his mom when it happened. But then when trial happened and they really broke it down, and for the first time you heard the kennel video and you saw the evidence from his car and the evidence from his phone, you realized, no, there was a window where he could do that. And I get everybody wants to argue this, and I get it. I mean, we're part of the problem, right? But as we often say, I would just urge people to exercise a little bit of patience. It's been delayed, unfortunately, but eventually there will be a trial unless someone pleads guilty, and we're going to learn a lot. Somebody asked earlier a civil question. It's been a long time since I practiced civil law. Can they sue for the leaks? I mean, that's a difficult question to even answer. It depends on what the civil causes of action are in Indiana. I'll say this. My understanding of Indiana law is, so it's not as if it was illegal to have those photos or to share those photos, just sort of like as a matter of law, is my understanding. But there was a protective order. So the judge had issued an order protecting those photos. And the people who are subject to that protective order, which are the people who have received discovery, they are not allowed to share them. And if they do, they violated the protective order and they are in contempt of court and they can be punished for it. The problem or, just happy accident of the First Amendment. If you're not under the protective order and you get those, it's not illegal for you to have them and whatever. It's not illegal for you to share them. And so that's where this gets complicated, because once they get out, there's really no clawing them back with any sort of legal process.
Yeah. So the whole jail thing, whether you should be in county or prison, it is.
Some of y'all never served any. Y'all never been to county jail. If you think county jail, is
Yeah,
like some
county
paradise.
jail usually has the least resources because of the way like taxes fund your jails, and it's typically a holding place for like DUIs, kind of the local county infractions. And then if you're going to be transported to the county courthouse because it's closer in proximity to where you have your hearing, so you don't have to drive, 3 or 4 hours the day of your hearing. So it typically doesn't have very many amenities in order to serve you, like mental health resources, like a courtyard for you to have outdoor time. And when you don't have access to those things, you know what happens? You don't get referred out to the YMCA to get to go play basketball there. You don't get to go out and get massages out there. If you don't have those resources in the county jail, it means you go without them at all. And, so these arguments are kind of, they're directed at the public who don't know.
Yeah, the Richard Allen sympathizers, which is fine. I want everything to be fair, of course. But if they're worried about his mental health, and then they want him to go to county and in prison is where he has the services, like you said. And also I was rereading some of the case files, and it showed how he went from suicidal to no longer being suicidal. So not only does that show the prison has mental health services, but effective ones. I mean, they helped make this guy who was suicidal to not be suicidal anymore and to start acting normal again. So why would you want to take him away from that mental health system and throw him into county?
Well, look, I think number one, he is detained. He's going to be detained until the end of this trial. And unfortunately, because of some of the actions of his own defense attorneys, that is being delayed. This is not the prosecution's fault, right? They didn't do this. Okay. Like if the people who want to defend the defense attorneys till the end of time and think everybody's just trying to undermine them or whatever because they're so brilliant. This is their fault. This is going to delay this. He's going to be behind bars. Wherever those bars are, he's going to be behind them. And some county jails are nicer than others. I've never been to county jail in Indiana. Never been in county jail. I've been to many of them, but I've never served any time in them. But ordinarily, and I'll say this just from experience of my defendants, and I told this, I can't even remember where anymore because we've talked about this so much, but recently I had a sentencing and the guy had a motion he was going to file that would lower his sentence. And the law is about to change. And when the law changes, he absolutely would win that. But right now, it's more like, does the judge want to acknowledge the fact the law is about to change and lower it sort of as a matter of like, I'll be nice to the guy. And I emailed the defense attorney and said, hey, if you want to delay this sentencing until the law changes, fine with that. That way your guy will be guaranteed to get it. He writes me back and says, no, man, my guy's ready to go to prison. He hates being in county. So I'm gonna roll the dice. And of course, when we got sentencing, I didn't oppose it and the judge did it and it all worked out. But the point is, his client was so ready to get out of county jail and get to prison that he was like, even if this means I have to serve a few more months, I'm just ready to go. And we see that so much. So I'm not saying maybe Richard Allen would rather be in county jail, but it's not such a difference between being in solitary in prison and being solitary in county, because in county, they're going to keep him in solitary too, because it's dangerous for him there too. It's not like in county, he's going to be hanging out with people. There's not so much of a difference that it's cruel and unusual that he's in a prison.
So I heard this, I don't know if it's a myth or not, but I heard that as a defense attorney, when you know your client's guilty and really all you could do is kind of move them around, that's something that you do, because when you heard of that, when they're guilty, the defense knows that their client's guilty. They'll just kind of move them around, try to make things comfortable as they extend things out. Or am I listening to the wrong people here?
I don't see why you would want to move your client to something, less comfortable for them, though. In this case, county would be less. Not so much. I mean, you can ask for a request to transfer. It's going to be based on space, but it has no effect on the actual case. The best thing you can do for your client, if they're guilty, is to move the case along so that they ultimately get sentenced and start serving their sentence sooner so that they can have a chance of getting out, right? That's actually the best thing you can do. Delaying it is not actually good because you don't get all the amenities afforded to the inmates once you start serving your prison sentence. So I haven't heard that before because it doesn't actually move the case along at all.
Let me just say this, and I know people are going to say I'm biased, and that's fine, because sometimes the truth sounds biased to people who don't want to hear the truth. Every single thing the defense has filed up to this point was about the defense. And that includes the motion to move him. They didn't like the fact they had to drive all the way to the prison. That's what it was about. And that's why they kept raising it. They wanted to move him because it was closer to them. It had nothing to do with Richard Allen. Nothing they have done has had anything to do with Richard Allen. They are out for themselves. To this day, they are out for themselves. And I would like Richard Allen to have defense attorneys who actually care about Richard Allen. That is my goal and my objective. And I think that is best. If you want justice in this case, both for Richard Allen and for the girls, you should want attorneys who actually care about Richard Allen. These attorneys are not that.
Bam. That's a mic drop there. Well, we'll start to wrap it up a little bit. Anything else, Alice? Anything you guys want to say? I don't, my pockets are only so deep, so I can only have you guys on for so long. Alice is way more expensive.
Especially now that you got Alice.
Discussion.
She's top dollar.
This is a 2-for-1 deal. No, thanks for having us on. This was such a fun conversation. And here's the thing, right? We may get heated in talking about this only because we're passionate about the law. And when you see fellow attorneys making a mockery of the court and the judicial system, it diminishes the profession and it diminishes the entire judiciary, which is upheld because we as a society have buy-in. That's why what these attorneys have done is so damaging. It's damaging for Richard Allen. It's also damaging for our entire judicial system. And that's why we get heated about it. Not because we have a bone in the fight. I don't know these attorneys, from Adam. It's because I care about justice being done and justice being done for Richard Allen and for our system to have integrity in the system.
And a very important question. It seems, Alice, are you a Scorpio?
I am not. I'm a Taurus.
Okay.
Mess with the bull. You get the horn.
There you go.
All right. Well, I want to thank you guys for being on, spending some time with me, and really appreciate it. And make sure to go check out their podcast. I listen on the podcast, and you guys also on YouTube when you do lives, and it's great. I really enjoy it. So it was great to have you guys on.
No, thank you
Appreciate
so
it.
much. It's been a
Thanks
pleasure.
so
We'll have to come
much.
back later.
All right. Thank you.